Welcome to No Opinion. I'm Terrell Hussain, and the document that we're going to be reviewing today is from the Superior Court of Fulton County in reference to the election interference case of Donald Trump. This is the order to quash, order on motion to quash, preclude, and recuse. On 20 March 2023, former President Trump filed a motion to quash the special purpose grand jury final report to preclude any state prosecuting agency from using any evidence derived from the special purpose grand jury's work and to disqualify the Fulton County District Attorney's Office from further investigation into prosecution of alleged interference with the 2020 general election in Georgia. On 28 April 2023, Kathleen Lathan, one of the alternate presidential electors advanced by Georgia's Republican Party in the aftermath of the 2020 general election, filed a motion joining the Trump motion. On 15 May 2023, the district attorney responded to the two motions, and certain media interveners did the same. Although the interveners' response was limited to opposing Trump and Lathan's effort to suppress the final report, finally, on 19 May 2023, a bipartisan collection of former federal and state prosecutors submitted an amicus brief opposing all relief sought by Trump and Lathan. At that point, the record was complete, as the court declined Trump's request to file a reply brief, finding the 500-plus pages of pleadings ample and sufficient to resolve the issues presented. 1. Precluding further prosecution. Having reviewed the pleadings, and the court now finds that neither Trump nor Lathan enjoy standing to mount a challenge at this pre-indictment phase of the proceedings to the continued investigation into the potential prosecution of possible criminal interference in the 2020 general election in Georgia. The movants asserted injuries that would open the door of the courthouse to their claims by either insufficient or speculative or unrealized. They are insufficient because, while being the subject or even target of a highly publicized criminal investigation is likely an unwelcome and unpleasant experience, no court ever has held that the status alone provides a basis for the court to not interfere with or halt the investigation. Trump knew this, and now Lathan does too. No doubt the threat of prosecution can weigh heavily on the minds of anyone under investigation, but without diminishing the seriousness of the burden that ordinary experience cannot support extraordinary jurisdiction. Trump versus United States, Ramden versus United States, citation, if the mere threat of prosecution were allowed to constitute irreparable harm, every potential defendant could point to the same harm and invoke the equitable powers of the court. The professed injuries are also speculative and unrealized because there is, as of yet, no indictment that creates the genuine controversy required to confer standing. Trump and Lathan presently theorize that evidence derived from the special purpose grand jury will be used to secure whatever indictments may be imminent. They further suppose that they will be named one or more charging documents, perhaps alone, that possibility is not enough to create a controversy, cause an injury, or confer standings. So Trump and Lathan necessarily further allege that the information from the special purpose grand jury is fatally tainted due to a procedural misstep made by the grand jury and the supervising judge. Assuming without finding that there were procedural infirmities, relief continues to elude the pair at this pre-indictment junction. Even if some of the evidence presented to the regular grand jury emanated from the unlawful investigation by the special purpose grand jury, this in itself is no moment for grand juries. Unlike petite juries are authorized to consider evidence without regard to its eventual admissibility at trial. State versus Lampo, evidence which grand jury receives in finding a true bill is not subject to inquiry. Finally, there are sound policy reasons buttressed by controlling precedent to defer resolution of these complaints until indictment. Prosecution is an executive branch function. The judicial branch should involve itself sparingly and delicately in the work that precedes formal charges. State v. Fulton. In the district attorney's role, an administrator or of justice, she has broad discretion in making decisions prior to trial about who to prosecute and what charges to bring. Evans v. State. Not even a trial court may interfere with a prosecutor's discretion or pursue criminal prosecution. After formal charges are brought, the locus of power, authority, and jurisdiction shifts to the court. Arguments like those being made prematurely in the pending motion can be more effectively and reasonably presented and ruled upon when the full picture of who is being charged with what has been painted. Guessing at what that picture might look like before the investigative docs are connected may be a popular game for the media and blogosphere, but it is not a proper role for the courts and formal legal argumentation. There will be a time and a forum in which Trump and Latham can raise their concerns about constitutionality of the special purpose grand jury statutes, about the performance of this particular special purpose grand jury and the judge supervising it, and about the propriety of allowing the Fulton County District Attorney to remain involved with whatever criminal prosecution, if any, results from the work of this special purpose grand jury. That time is not now. That forum is not here. Should either or both movements be indicted, they can raise all these issues, as they undoubtedly will, before the judge who is actually confronted with the case and controversy, whether that judge be here in the Superior Court of Fulton County or instead in the Northern District of Georgia. 2. Quashing the final report. Trump and Latham both seek to have the special purpose grand jury's final report locked away from public view forever. Such permanent silence of that investigation body is not what either statutory or case law generally allows. When a grand jury recommends to the court that its pronouncements be published, the judge shall order the publication. Emphasis added in Grinnell County grand jury holding that USCR 21, which restricts the court's ability to limit access to court files, encompasses presentments made by the grand jury in open court at the conclusion of the grand jury's investigation. However, a more complete analysis of Trump and Latham's claim due process rights concerning publication of the final report, assuming, arguendo, that they are named in it, is unnecessary at this time because those portions of the report have not been released. Will, per the court's earlier order entered on 13 February 2023, remain out of public eye until district attorney's final charging decision, which she has widely advertised will occur sometimes in the first 2 weeks of August. After that, the court will, as promised, revisit the questions of releasing the remainder of their final report. Until then, motions to quash or expunge are moot. 3. Disqualifying the district attorney. Finally, Trump and Latham seek to have the district attorney and her office disqualified from any further involvement in this matter. Trump Mott at 1. This is a bold request. A significant showing must be made to grant such uncommon relief. There are 2 primary grounds for disqualifications of a prosecuting attorney. 1, conflict of interest, and 2, forensic misconduct. Williams v. State 258. Neither grounds has been shown here. The conflicts of interest that typically suffice to support a motion to disqualify arise when the prosecutor previously represented the defendant with respect to the crimes charged, when she consulted with the defendant in a professional capacity with regards to such crimes, or when she has acquired a personal interest or stake in the defendant's conviction. Ventura v. State, citation omitted, Forensic misconduct occurs when, for example, the prosecutor improperly expresses her personal beliefs in a defendant's guilt. None of that has happened, yet there is no evidence or even contention that the district attorney or any of her many assistants ever represented Trump or Lathan or consulted with them in a professional legal capacity, nor is there evidence of any direct financial interest that any member of the district attorney's office has in the outcome of the case. Unlike the sole case upon which movements rely, the fractured, inopposite, and unpersuasive opinion of Young versus U.S. and as the forensic misconduct, while both sides have done enough talking, posting, tweeting, Xing, the press conferencing to have hit and perhaps stretched the bounds of the Georgia rule of professional conduct. Neither movement has pointed to any aversion from the district attorney or her team of lawyers expressing a belief that Trump or Lathan is guilty or has committed this or that offense. Rather, the consistent and persistent theme has been the standard of fare of pursuing the evidence where it leads us, holding everyone accountable and no one being above the law. The drumbeat of the district attorney has been neither partisan in the political sense nor personal, in marked and refreshing contrast to the stream of personal invective flowing from one of the movements. Put differently, district attorney's office has been doing a fairly routine and legally unobjectionable job of public relations in a case that is anything but routine, nor of what movement cites rises to the level of justifying disqualification. And all of it collectively falls far short of what prompted the district attorney's disqualification from the investigation into Lieutenant Governor Jones. The prosecutor is not a neutral party and does not need to pretend to be. She has a cause she has sworn to pursue, and in that pursuit of justice, she is necessarily a partisan in the case. If she were compelled to proceed with the same circumspection as the judge and jury, there would be an end to the conviction of criminals. State v. Sutherland, citation omitted. For these reasons, Trump and Lathan motions to disqualify the district attorney are denied. Former President Trump and alternate elector Lathan's motions to preclude any state prosecuting agency from using evidence derived from the special purpose grand jury work are dismissed for lack of standing. Their motion to quash or expunge the final report of the special purpose grand jury are denied as moot, and their motion to disqualify the district attorney and her office are denied. So ordered this 31st day of July 2023. Judge Robert McBurney, Superior Court of Fulton County. Hey, if you like this type of content, like and subscribe. Let me know if there's some things that I can do to make it more better for you. Let me know. We're looking to improve. I find this kind of information fascinating. I like to know exactly what is being said. I don't necessarily like being told what is being said and why it's being said. Just tell me what's being said. If you like that kind of information, that's what we're going to put here. No opinion, no anything. We're just going to read the words as they are printed, maybe with a little bit of stink on them. Thank you for watching.